If I asked you right now whether your will controls everything you own, most people would give a confident answer. They would say yes. And that confidence is exactly where the danger begins. Because in the real legal and financial world, a will does not control everything you own. It controls only a particular category of assets. That category matters. But it is much narrower than most families believe. And when people misunderstand that, they can spend years thinking they have protected their family when in fact the most important assets in their life are moving under completely different rules. I have learned in investing and in life that the things that hurt people most are often not complicated because they are hidden. They are complicated because people assume they understand them. Estate planning is one of those things at its core. Estate planning is not about paperwork. It is not about having a binder in a drawer. It is not even about whether you have a will or a trust. Those are tools. The real issue is control. Who is in control? When does that control change? How do assets legally move from one person to another when you are alive, when you are incapacitated, and when you are gone? Those are the real questions. Once you understand those questions, wills and trusts become much easier to understand. But if you skip them, you can sign documents that look impressive and still leave your family exposed to court delays, public filings, frozen accounts, unintended heirs, and conflicts that could have been prevented with better structure. This is where most people get it wrong. They think the law will look at what they meant. They think the court will say, what did this person probably intend? They think fairness will control the outcome. But the legal system is not built that way. It is mechanical. It does not run on feelings. It runs on structure. When a person dies, the system asks a few very cold questions. How was the asset titled? Was there a contract? Was there a beneficiary designation? Was the asset owned by a trust? Did it fall into probate? That is the sequence. That is the machine. And the machine will follow the paperwork even when the paperwork produces an outcome nobody in the family expected. That is why the first principle is this. Assets transfer based on legal structure, not personal wishes. That sounds simple, but it is the difference between an estate plan that works and one that only feels like it works. There are three basic ways assets move after death. Some assets move by contract, some assets move by title, everything else may have to move through probate. When you understand those three buckets, you start to see why a will is important but limited. You start to see why trusts exist. You start to see why beneficiary forms can quietly override years of planning. And you start to see why a family can walk into a lawyer's office with a will and walk out thinking they are finished, when the real work was never done. Let us start with assets that move by contract. A retirement account often moves by contract. Life insurance usually moves by contract, payable, on death and transfer. On-death accounts move by contract if they were set up correctly. When you name a beneficiary, you are not merely writing down a preference. You are creating a legal instruction between you and the institution holding that asset at your death. The contract executes, the account does not wait for your will. It does not ask the probate court for permission. It does not ask your family what you probably wanted. It pays the named beneficiary. That can be a very good thing when the beneficiary form is correct. It can also be a disaster when the form is outdated, if your will says everything goes to your children, but your life insurance policy still names a sibling, a former spouse, or a person you named 20 years ago and forgot to update. The beneficiary form wins every time. This is one of the most misunderstood parts of estate planning. People update a will and assume they updated the plan, but a will does not rewrite beneficiary forms. It does not reach into retirement accounts and change contracts. It does not override what you already told the insurance company. This is why I think in systems each asset has to be mapped. You do not have one estate plan. You have a network of legal instructions, and those instructions must point in the same direction. If they conflict, the strongest legal mechanism wins, and a beneficiary form is often stronger than the will. The next way assets move is by title. This is ownership structure. If you own a home jointly with rights of survivorship and you pass away, the surviving owner usually becomes the full owner automatically. If you have a joint bank account with survivorship rights, the same principle may apply. The title controls the transfer. Again, your will does not control that. Imagine a second marriage. A man owns a house jointly with his current spouse. His will says that his share of the house should go to his children from a previous marriage. He believes he has provided for them. They believe the house is partly protected for them. Then he dies. The house passes automatically to the surviving spouse because of how it was titled. The will does not change that. The children may be angry, the surviving spouse may be surprised, everyone may say, but this is not what he intended. And that may be true. But intention is not the mechanism. Title is the mechanism. This is not the law ignoring the will. It is the law applying the structure that already existed. Ownership structure trumps testamentary wishes. That is why estate planning cannot be done by looking at a document in isolation. You have to look at the asset, the title, the contract, the beneficiary, the family structure, and the practical result. The third bucket is probate. Probate is the court-supervised process for transferring assets that do not move by contract, do not move by title, and are not already owned by a trust. This is the bucket where a will matters. A will directs the distribution of probate assets. That sentence is short, but it is one of the most important sentences in estate planning. A will directs probate assets, not all assets. Probate assets if an asset has no beneficiary designation, no survivorship title, no payable on-death instruction, no trust ownership, and no other transfer mechanism, then it may fall into probate. That is where the will operates. A will is a revocable legal document. While you are alive and mentally competent, you can change it, you can replace it, you can revoke it. But while you are alive, it does not move assets. It does not manage assets. It does not help your family access accounts if you are incapacitated. It just sits there. It becomes operative at death. And when it becomes operative, it usually begins the probate process rather than avoiding it. This surprises people. They think a will avoids court. It does not. A will is filed with the court validates it, the executor is appointed, the estate is administered through a public legal process. Creditors may be notified, assets may be inventoried, final bills and taxes may be paid. Then the remaining property is distributed. That is what a will does. A will can be very useful. It can name an executor, which is the person responsible for carrying out the instructions. The executor gathers assets, works with the court, pays final expenses, and distributes what remains. A will can name guardians for minor children. This is not optional for parents. If you have minor children, the will is where you formally nominate the person you would want to raise them if both parents were gone or unable to do so. A will can direct the distribution of assets that fall into probate, but it cannot override a beneficiary designation. It cannot override joint ownership with survivorship rights. It cannot avoid probate. It generally does not reduce estate taxes by itself. It does not provide creditor protection. It does not manage incapacity while you are alive. When people treat a will as if it controls everything, they build their plan on a false assumption. And false assumptions are where real risk lives. Let me make this practical. Suppose a person dies with a will that says everything goes equally to their children. They also have a life insurance policy naming their sibling as beneficiary, and they own a home jointly with their spouse. What happens? The life insurance goes to the sibling because the beneficiary form controls. The house goes to the surviving spouse because the title controls, the will controls only whatever probate assets remain. That is the whole lesson. The system does not ask whether that feels fair. It does not ask whether the children expected more. It does not ask whether the person forgot to update the insurance policy. It follows the paperwork. This is why good estate planning starts with asset mapping. You list what you own, you identify how each asset is titled, you identify whether a beneficiary is named, you identify whether the asset is in a trust. Then you ask what happens if you die and what happens if you become incapacitated. If you do not do that, you are guessing. And guessing with your family's future is not a good system. Now let us talk about trusts. A trust is not just a document. It is a legal relationship. A person transfers property to a trustee, and the trustee manages it for the benefit of beneficiaries. The person who creates the trust is often called the grantor. The trustee has legal control. The beneficiaries receive the benefit. This separation between control and benefit is the essential idea. One person or institution can manage the asset while another person benefits from it. That allows the creator of the trust to define timing, rules, continuity, and protection from chaos. It allows a family to say, this money should not simply be handed out all at once. It should be used in a certain way at certain times under certain conditions. That is what trusts do well. They create structure. A trust can handle complexity in ways a simple will often cannot. It can manage assets for minor children. It can stagger distributions. It can protect a surviving spouse while preserving assets for children from a prior marriage. It can create continuity if someone becomes incapacitated, and if it is a properly funded revocable living trust, it can keep assets out of probate. The phrase properly funded is the part many people miss. Creating a trust document is not magic. If you sign a trust and then leave your house accounts and other assets titled in your individual name, the trust may not control them. The assets have to be retitled into the trust or directed to the trust through beneficiary designations or other planning tools. The structure only works when assets are placed inside it or connected to it correctly. An unfunded trust is like an empty container. It may be beautifully drafted, but if nothing is in it, it cannot do much. There are different kinds of trusts, but most families are usually talking about one of two categories. A living trust is created during your lifetime. It can be revocable or irrevocable, and it can operate while you are alive. During incapacity and after death, a testamentary trust is created through a will. It does not exist while you are alive. It comes into existence at death through probate. That means a testamentary trust does not avoid probate. It is born out of probate. This distinction matters. A testamentary trust can still be useful. For example, if parents have minor children, they may use a will to create a trust after death so the children do not receive assets outright at age 18. The trust might allow money to be used for health, education, maintenance, and support, then distribute what remains when the child reaches a more mature age. That can be a very good structure. But it is not a probate avoidance structure. It gives control after death. It does not avoid the court process that creates it. Most people who ask whether they need a trust are usually asking whether they need a revocable living trust or whether a will is enough. A revocable living trust is created while you are alive. If you are the grantor and trustee, you usually remain in full control while you are competent. You can buy and sell property. You can change the trust. You can revoke it. You can move assets in or out of it day to day. It may feel like nothing changed, but structurally something very important changed. You created a legal framework that can continue if you become incapacitated and can continue after you die. If you become ill, develop dementia, suffer a stroke, or otherwise become unable to manage your affairs. A successor trustee can step in and manage the trust assets without the family first asking a court to appoint a guardian or conservator. To me, this is one of the strongest reasons to consider a trust. People often think estate planning is about death, but in many families, the harder and more expensive problem is incapacity. Someone is still alive, but they cannot sign checks, pay bills, manage accounts, sell a house, or make financial decisions. The family knows what needs to be done, but legally they may not have authority to do it. That creates limbo. Accounts can be frozen, bills can pile up, real estate decisions can be delayed. Family members may have to petition the court, medical records may be required, hearings may be scheduled. And while all of that happens, the family is already dealing with fear, grief, and uncertainty. A revocable trust can reduce that friction. It is not the only document needed, but it can give the successor trustee a role that already exists. They are not begging for permission from the court. They are stepping into a structure you already created. That is a big difference. A durable financial power of attorney can also help, and I believe every adult should have one. It allows someone you choose to act on your behalf for financial matters if you become incapacitated. But powers of attorney can be questioned. Banks may reject them. Institutions may demand their own forms. They may be treated differently from account to account. A trust works differently because the trust owns the asset. The successor trustee manages trust-owned assets under the trust document. That tends to create more continuity. That does not mean a trust replaces a power of attorney. It does not. A good incapacity plan often includes a revocable trust, a durable financial power of attorney, a healthcare power of attorney, and a living will or advance directive. These documents work together. The trust handles trust assets. The financial power of attorney handles assets outside the trust and other financial matters. The healthcare directive handles medical decisions when those documents are missing. Families can end up in court at the worst possible time. That is not planning, that is crisis management. A revocable living trust can also provide privacy. Probate is a court process, and court filings often become public records. A will submitted to probate can become visible. The assets, beneficiaries, and distribution structure may become part of the record. Trust administration is generally private. For some families, that privacy does not matter much. For others, it matters a great deal if there are family conflicts, substantial assets, blended families, public reputations, or simply a desire to keep family affairs out of the courthouse. Privacy can be a meaningful advantage, but we need to be precise here. A revocable trust does not, by itself, reduce estate taxes. It does not protect assets from creditors while you maintain control. It does not remove assets from your estate for tax purposes. Why? Because control and tax treatment are connected. If you can revoke the trust, change it, and control the assets, the IRS generally treats the assets as yours. That means the trust changes administration, not ownership for tax purposes. This is where many people are misled. They hear trust and assume tax savings. That is not accurate. Some irrevocable trusts can provide tax planning, asset protection, Medicaid planning, or advanced wealth transfer benefits, but they usually require giving up control, and giving up control is a serious trade-off. A revocable living trust is mainly about administration, continuity, privacy, and probate avoidance. When properly funded, it is not a magic tax shelter. That distinction matters because a person should not buy a tool for a benefit the tool does not provide. Now compare that with a will. A will is simpler. It is usually cheaper to create. It is easier to understand. It can be perfectly appropriate for many families. If your estate is straightforward, your beneficiary designations are correct, your assets are modest, your family structure is simple, and your state's probate process is not especially burdensome, a will may be enough. Every adult should have a will, but a will has limits. It does not help during incapacity. It requires probate for assets it controls. It can become public once filed. It does not manage assets privately during life. It does not give a successor trustee immediate authority to manage trust property because there is no trust property. So the real question is not, is a will good or bad? The real question is, what problem am I trying to solve? If the problem is naming guardians for minor children, you need a will. If the problem is simply directing a small estate through probate, a will may be sufficient. If the problem is avoiding probate, a will does not solve that. If the problem is privacy, a will may not solve that. If the problem is incapacity management, a will does not solve that. If the problem is complexity in family structure, timing, or distributions, a trust may solve what a will cannot. This is how I like to think about planning. A will is death plus probate plus public process. A revocable living trust is life plus incapacity plus private administration. That is not a perfect formula, but it is useful. A will waits until death and works inside the court system. A revocable trust can operate during life, during incapacity, and after death, usually outside the public probate process if funded correctly. Again, the phrase, if funded correctly, is essential. I have seen many people think they have a trust because they signed a document, but the house was never retitled. The bank accounts were never moved. The beneficiary forms were never aligned. When they die, the family discovers that the trust exists, but the assets are still outside it. Then probate may still be required. The trust did not fail. The funding process failed. In investing, structure without execution is just theory. Estate planning is the same. There are several misconceptions that create a lot of damage. The first is that trusts avoid taxes. Revocable trusts generally do not. They are still treated as your assets because you still control them. Certain irrevocable trusts may have tax advantages, but that is a different conversation and usually involves giving up control. The second misconception is that having a trust automatically avoids probate. Only a properly funded trust can do that. The document itself is not enough. The third misconception is that a will controls everything. It does not. It controls probate assets, beneficiary forms, joint ownership, and trust ownership can override the will. The fourth misconception is that testamentary trusts avoid probate. They do not. They are created through the will and therefore through the probate process. Their value is control after death, not avoiding probate. Once you understand these misconceptions, you start to see that estate planning is less about collecting documents and more about aligning mechanisms. Contract title, trust ownership, probate, incapacity authority, guardianship, privacy, tax treatment. Each mechanism has a job. Good planning gives each job to the right mechanism. Guardianship deserves special attention. If you have minor children, a will is not optional. A trust cannot nominate a guardian. A beneficiary designation cannot nominate a guardian. Your will is where you formally state who you want to raise your children if something happens to you. The court still has the final authority because the court must act in the best interest of the child. But courts generally give strong weight to a parent's nomination unless there is a serious reason not to. Without that nomination, you leave one of the most important decisions of your child's life to a court process and to family members who may disagree. That is not a risk I would want anyone to take. For families with minor children, the question is often not will or trust. It is usually will and maybe trust. The will handles guardianship, the trust may handle asset management. This is important because leaving money outright to minor children can create problems. A child cannot manage a large inheritance, a court may have to supervise it. Then at a certain age, depending on the structure, the child may receive the money outright, even if they are not mature enough to handle it. A trust can provide rules, money can be used for health, education, maintenance, and support. Distributions can be staggered. A trustee can manage assets until the child is older. The family can create a path rather than a sudden transfer. That is what structure does. It takes chaos and turns it into a process. Now let us be fair about when a trust may not be necessary. Not everyone needs one if most of your assets pass by beneficiary designation. If your accounts are simple, if you have no real estate or only modest assets, if your family structure is straightforward, if you are comfortable with probate in your state, and if you have durable powers of attorney and healthcare documents in place. A will might be enough, costs matter, trust can be more expensive to draft, they require administration, assets have to be retitled, beneficiary forms have to be coordinated, the plan has to be maintained. A simple plan that is correct may be better than a complex plan that nobody understands and nobody funds. The goal is not to have the most sophisticated estate plan. The goal is to have the right estate plan for the risks you actually face. A trust starts to make more sense when the structure solves a real problem. Maybe you own real estate in multiple states without a trust. Your estate may need probate in more than one state. A trust can consolidate administration. Maybe privacy matters to you. Trust administration is generally private, while probate can be public. Maybe incapacity planning matters to you. A successor trustee can step in under a trust structure without waiting for a court process. Maybe you have a blended family, you want to provide for a surviving spouse but also protect children from a prior marriage. Maybe you have beneficiaries who should not receive money all at once. Maybe your state's probate process is slow, expensive, or burdensome. Maybe you simply want your family to have less friction during an already painful time. Those are real reasons. The right plan depends on your assets, your family, your state law, your priorities, and the problems you are trying to prevent. This is why I am careful with absolute statements. Some people say everyone needs a trust. That is not true. Some people say a will is always enough. That is not true either. The truth is more useful. You need a structure that matches your life. And the first step is not signing documents. The first step is understanding what controls each asset. If I were walking through this process, I would start by listing every major asset I own: retirement accounts, bank accounts, brokerage accounts, life insurance, real estate, business interests, vehicles, personal property, anything meaningful. Then I would identify the transfer mechanism. Does it have a beneficiary? Is it jointly owned? Is there a payable on death or transfer on death designation? Is it titled in a trust? Would it fall into probate? Then I would ask what happens if I die. Then I would ask what happens if I become incapacitated. Those are different questions. Many people plan for death and ignore incapacity, but incapacity can be the event that creates the most immediate stress. If I cannot manage my affairs, who can pay bills? Who can access accounts? Who can sell assets if needed? Who can manage trust property? Who can make healthcare decisions? Who has authority that institutions will recognize? That is practical planning. It is not dramatic. It is not emotional. It is a system. And systems matter because bad systems fail at precisely the moment when the people you love have the least energy to fix them. Estate planning is ultimately an act of reducing friction for the people you love. It is not about predicting the future perfectly. No one can do that. It is about accepting that life includes death, illness, uncertainty, blended families, changing relationships, financial institutions, courts, taxes, and human emotion. Then you design a structure so that when stress arrives, your family is not also trying to decode your intentions. A will has a role. A trust has a role. Beneficiary designations have a role. Joint title has a role. Powers of attorney have a role. Healthcare directives have a role. The mistake is believing that one document does everything. A will does not control everything. A trust does not solve every problem. A beneficiary form can quietly override your will. A joint title can defeat a carefully written clause. An unfunded trust can leave assets in probate. A missing power of attorney can leave your family stuck in court while you are still alive. The system will follow the structure, so the structure has to be intentional. If there is one idea I want you to take from this, it is that estate planning is not about what you feel is fair, it is about what the legal mechanisms actually do. The law does not read your mind, it reads the title, it reads the contract, it reads the beneficiary designation, it reads the trust. It reads the will only for the assets the will actually controls. That is why the most responsible thing you can do is not simply to say, I have a will or I have a trust. The responsible thing is to ask whether your documents, titles, contracts, and beneficiaries are all aligned with the outcome you want. That is the work. It is not exciting work. It is not the kind of thing people brag about. but it prevents some of the most painful mistakes a family can make, and like so many things in life, the best time to build the system is before the system is needed. By the time someone is incapacitated, the family may already be in court. By the time someone has died, beneficiary forms have already become decisive. By the time probate begins, the process is already public. By the time the family discovers the trust was never funded, it is too late to fund it. Planning only works when it is done before the event. That is why I think about estate planning the same way I think about risk management. You do not buy insurance after the fire. You do not build a bridge after the flood. You do not create legal authority after incapacity, and you do not fix beneficiary mistakes after death. You build the structure while life is calm enough to make good decisions. Then, when life becomes difficult, the system carries some of the weight. That is what good planning does. It does not eliminate grief. It does not remove uncertainty. It does not make hard moments easy, but it can prevent a hard moment from becoming a legal and financial disaster, and that is worth taking seriously.